Hi, veterans. I'm doing a video today on clear and unmistakable error, or Q. If you spend any time at all in the various veterans forums or communities where people talk about claims, you're gonna hear the term Q thrown about a lot. People sometimes talk about it like it's a magic bullet, a way to go back in time, fix mistakes that VA made a long time ago, and get all the back pay you should have gotten if they had gotten it right the first time. Q is those things, but it can also be very misleading. And I say that because Q is something that's very difficult to prove and win. You have to have a very clear idea of what the law is, and not just what the law is, but how it applies to your case and what the law was at whatever time the original decision was made. You have to know when VA got evidence, when it was added to the file, what the evidence was, um, and again, what it was on the specific date the decision was made. And so all of those things, that's a lot. It can be a real challenge. Um, that said, you know, it's a tough road to win, but if you win, then it's as if the original bad claim never happened. And so I wanted to set out to explain what Q is and how it can work through the lens of an actual case. Um, uh, this was a client of mine who we filed a Q for him last summer. He gave me permission to discuss the case, obviously without any personal information. And so we're going to walk through um, what a queue is, what it's not, what the requirements are, and then how it applied to his particular case, how we filed it, and how we won. Uh, so let's talk about what a queue is. Okay, so a queue is technically not a claim. So it's an attack on a previously decided final claim. Okay, and so when I say final, I mean that you're past all possibility of appeal. So if the decision was made in the last year, you're in your appeal period. You can file a regular appeal, put all your arguments in. That, by definition, is not a queue because a queue has to be a final claim completely outside of any appeal window. Now, the second thing about a queue, and the toughest one really, is that it has to be an error that's so obvious that no two reasonable people could possibly disagree. Okay, so that's a tough hurdle to climb because people can disagree about just about anything. The error has to be undebatable, absolutely clear. Um, and so it has to show one of two things. So either the facts as VA knew them at the time of the original decision weren't in front of the rater, or the rater overlooked those facts. And so we'll talk about what that means. Um, and or the second option is that the original decision incorrectly applied the law and the regulations as they existed at the time of the decision. So that first option, the VA, they they didn't have the facts in front of them, or they overlooked those facts. So that would be a case of, um, for example, I have one client who's got a Q claim pending right now where the client identified that they had been getting treatment at the Boston VA in the 1990s, and VA never requested the records. It's right there in the C file that the veteran said they were getting treated at the Boston VA. Rating decision was issued, and they did not request those records. The records weren't in the C file, but we were able to get them paper copies of handwritten documents from the Boston VA and submit them. And of because the veteran had identified the records, and because VA had possession of the records when they made the decision, then the facts as VA knew them at the time weren't in front of the rater. Okay. Uh, for for incorrectly applying the law and the regulations, we'll talk about that in this case study. But basically, if they didn't follow their own rules, then that could be a Q. Okay. So both of these two types of Q require that you know what the evidence was, what was available at the time of the decision. Okay. And you need to know what the regulations were at the time. So for the first, obviously you need a copy of your complete C file. Okay, and for the second, you need a copy of the Code of Federal Regulations or the U.S. Code as of the date the decision was made. Okay. As I said, a Q has to be based on a final claim. If you're still in your appeal window, it's not a Q. You can still file your appeal, obviously, and you can make your argument. If they've made a mistake, you can point out that mistake. But it's not a Q. Since you're in your appeal period, it can go back anyway. Next thing is your Q argument has to be specific. You can't just send in something that says VA made a mistake. I should have been rated at whatever percentage. You have to specify exactly what evidence was overlooked and exactly what regulations were misapplied. Okay. And finally, for a Q, it has to have what they call manifestly change the outcome. That means that it can't be a harmless error. You have to be able to show that because of the error, you lost benefits you were entitled to. Okay. So let's talk about what is not a Q. Okay. 38 CFR gives examples of what isn't a Q. Those can include a change in diagnosis. So I'm going to give a really good example. You filed a claim for cancer, and the VA doctors at the time, they did an examination and they said you don't have cancer, and they deny your claim. A year later, a different doctor runs the tests and determines that you did in fact have cancer. That wouldn't be a Q because the medical evidence VA had at the time is what the medical evidence was at the time, which is unfortunate because that means that if a VA doctor or a VA contract examiner makes a medical mistake, then there's no recourse in terms of benefits because by law the VA raters have to follow what the medical evidence is that they receive. So another example of something that's not a Q is if VA fails in their duty to assist. They didn't send you to an exam or they didn't request your records from the Department of the Army. Those are cases where it wouldn't be a Q. Okay. And finally, it's disagreements about how the facts were weighed. I'm going to a couple of different examples. You've got evidence in your file for a disability, but there's also evidence that goes against. Like let's say there's two medical opinions, and there's also evidence in the service treatment records and in the VA records. And if the rater looks at all of that evidence and they decide that the negative evidence outweighs the positive evidence, that wouldn't be a Q. Um, so let's talk about this particular case. So my example of a Q, this was a gentleman, we'll call him Mr. S. He's a Gulf War veteran. The U.S. Navy, served in the early 1990s. During his service, he suffered a traumatic brain injury and back injuries, and those resulted in him being medically retired. And the main disability that forced the medical retirement was involuntary urinary retention, which means he was unable to urinate and he had to be catheterized. Uh, Sometimes I'll have to edit that out. He had to be catheterized periodically, and then he had to learn how to do it to himself in order to be able to urinate. And so in July 1994, VA issued a rating decision granting 10% for urinary retention. And quoting from the July 1994 rating decision, they said the veteran was noted to have a twisting injury to his back in October 1992. He complained of urinary retention requiring catheterization approximately once or twice per week. Veteran was also noted to have urinary leakage with soiling. Current VA examination reveals that the veteran continues to have urinary retentive problems which require self-catheterization approximately once or twice per month. Okay. Now, in 2018, decades later, VA granted an increase to 40% for this condition. Now, when when I first started working with this client, we were looking at other conditions. This was a long dead decision, and so our initial round of looking at things was for current issues. However, we kept kind of circling back around this decision because even though he's got 40% now, um, the 10% seemed low, and when I looked in the current regulations, it was clear it was low because he should have been rated 30%. But then the question becomes, when did that regulation come into effect? And so I went and pulled the copies of the 38 CFR for 1994 and the current CFR, and that really made everything very, very clear. Okay, so this particular condition was rated under Diagnostic Code 7512, which is chronic cystitis from the 1993 edition of 38 CFR. And Diagnostic Code 7512 at that time said that mild chronic cystitis should be granted a 10% rating. And that's what the veteran got. It's very clear. Problem is, in January 1994, which was 6 months before VA made this decision, VA had adopted a final rule which revised the rating criteria. And in that new rule that they established in January 94, they said that 7512 should be granted under voiding dysfunction. And under voiding dysfunction, any intermittent or continuous catheterization is evaluated with a 30% rating. Okay, so based on that, I'm looking at the old regulation. Remember the 1993 edition, and then I'm looking at the new regulation, the 1994 edition, and there was a difference. And so I found the Federal Register notice, which was from January 19th, 1994, where they announced the new rating criteria. It went into effect immediately. And so that meant that when they made this decision, they had used the wrong rules. Okay, they misapplied their own regulations. And it seems pretty clear to me that what happened is straightforward. Um, Back then, the VA offices were mountains of paper. The files were paper, the C files, just stacks of it. And you can see pictures if you go look on the web of these regional offices where literally the floors were buckling in, and it was like became hazardous to be in them because there was so much paper. Um, and so what I believe happened was that this raider had sitting on their desk a copy of the Code of Federal Regulations from 1993. They hadn't gotten the new edition yet. They didn't know about this notice, and that was that. So they just rated it based on what they had at the time. That is a clear and unmistakable error. So in order to win this, what we did was we wrote a detailed appeal brief that laid out the case. I included a copy of that Federal Register notice from January 1994 announcing the final edition of the new regulations. I included with it a copy of the 1993 rating schedule and the 1994 rating schedule. Okay. Then I walked through in my written argument what are all the requirements for Q. Okay, was it a change diagnosis? No. Was it a failure in VA's duty to assist? No. Was it a disagreement over how the facts were weighed? No. It was a final decision, had been final for decades. And did it manifestly change the outcome? Absolutely did. The veteran was rated 10% from 1993 until 2018, and that was an incorrect rating. So we filed the Q allegation in July of 2022. It was granted in November, and the difference in the rating, the veteran received a back pay award of $68,000. So that was a clear victory. Now, how can you apply this information? First, I recommend you don't. If you want to win a Q claim, I recommend you get representation from an accredited agent or an attorney who's familiar with how to file these and what type of information needs to be in there. Okay. So you have to have a deep understanding of the law really to get any success with these. But if you're going to file it yourself, okay, you want to make sure you have just a clear understanding. What was the law at the time the decision was made? Okay. What was the evidence they had at the time the decision was made? It means you're going to need to get a copy of your C file and look through it chronologically by date of when they received each item of evidence. Okay? Because if the evidence is in the file, but they didn't cite it or they didn't use it or they ignored it, then that may be something you'll have a chance with. You want to know what they overlooked, what was in there, what wasn't. It's really important to do your research, really get a handle on what were the regulations around whatever condition it is, whatever the decision was for your queue. Get advice, consult with others, read the CFR, get a good handle on this. If you do have a possible queue, I recommend you explore an attorney or an accredited agent, somebody who can look through your file and make some recommendations. I'm currently taking clients, and so I am looking at cases, and I'm particularly interested in queues and Gulf War claims, and I love pouring through claims from the 1990s. And frankly, it's because there are so many mistakes in every one of those files. If you had a VA claim in the 1990s, yeah, I would encourage you to have someone take a detailed look at it because you just never know what you're going to find. So anyway, feel free to reach out if you have questions. I can be contacted by email. I'll post that in this video. I can also be contacted through my Facebook page or my website. Thanks and good luck.